This legal whirlwind between Blake Lively and Justin Baldoni has been unfolding for a while. You've probably heard the main claims and counterclaims already, but here's the twist. In the latest round of drama, Lively's lawyer suddenly quit. The New York Times got pulled deeper into the fray, and previously solid accusations started crumbling under fresh scrutiny. Let's dive right in and break down what's happening now. No fluff, just the raw developments you need to know. Not long ago, Blake Lively's lawyer, Meryl Conant, decided to walk away from the case altogether. On paper, Conant's exit may seem like just another attorney swap, but insiders say it's a massive red flag. After all, attorneys rarely jump ship in the middle of a high-profile legal battle unless they see major issues ahead. Speculation is rampant. Some say Conant was tired of defending claims that seemed to get shakier by the day. Others point to mounting pressure from Lively's team, who allegedly refused to pivot their strategy, even as new evidence poked holes in the story. Whatever the reason, the departure sent a clear signal. Something big is unraveling behind the scenes, and the cracks are now too large to hide. For months, rumors swirled that Lively's allegations about SUL harassment and other forms of misconduct had little hard evidence backing them up. Conant, once the shield for Lively's legal position, apparently saw the writing on the wall. It's one thing to represent a client who wants to fight to the bitter end. It's another to continue when proof is slipping away faster than you can grab it. When Conant left, many assumed it was purely a legal matter. But a lot of insiders say that was just the tip of the iceberg. We're talking about deeper accusations of PR manipulation, collusion even, between Lively's team and major media outlets. More than once, we've seen celebrity PR machines try to spin the narrative by feeding stories to trusted journalists. In this case, speculation centers on whether the New York Times was nudged to frame Lively's accusations as airtight. This might sound like a conspiracy theory, but multiple leaked documents suggest a deliberate media push.
How the New York Times actively vouched for the veracity of its false narrative.
Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
We're complicit here. You guys were involved in this every step of the way.
Some watchers believe the moment Lively's team realized they weren't going to find a smoking gun, they pivoted to a PR campaign. If you can't win convincingly in court, you might try to win big in the court of public opinion. PR experts say it's a classic strategy. Paint your target as guilty from the start, let headlines do the rest, and hope official proceedings play catch-up. But it looks like that plan started to backfire the minute Justin Baldoni's lawyer, Brian Fredman, caught wind of it. For those who missed it, Fredman is not just going after Lively's arguments, he's also taking on the New York Times itself. According to Fredman, the Times didn't merely report Blake's allegations. Instead, they all but stamped them as fact, leading the public to believe these claims were thoroughly vetted and authenticated. This move has sparked a fierce debate over the paper's journalistic integrity. On one side, the Times insists it was merely covering a breaking legal saga, nothing more. On the other side, Fredman counters that the newspaper was so committed to Lively's narrative that it crossed the line from reportage into biased advocacy. Here's where it gets even wilder. Fredman says the Times might have rushed the publication right before the holidays, giving Baldoni's side barely any time to issue a rebuttal. If that's true, the rush job angle could weaken any defense that the Times was just doing routine journalism. Plus, by rushing out the story and presenting allegations as if they'd been confirmed, the Times could be on the hook for something far more serious, what Fredman calls actual malice, the legal standard for defamation cases. What shattered Lively's lawsuit more than anything were the scores of documents released by Baldoni's team. We're talking emails, text messages, and behind-the-scenes communications that allegedly contradict Lively's claims. Some viewers might say, so what if there's a bunch of emails? Isn't that normal in lawsuits? Yes, but here's the kicker. Many of these messages apparently show Lively or her associates discussing ways to strengthen their story without real evidence, essentially acknowledging that their claims might not stand on their own. Even more damaging are the documents that hint at strategic coordination with certain journalists, possibly to ensure coverage portrayed Lively as a victim and Baldoni as a villain. There's nothing illegal about wanting favorable press, but if you're actively shaping a narrative you know might not be true, it starts looking more like a smear campaign than a legitimate legal stance. With these leaks out in the open, the initial shock value of Lively's allegations has faded. People who once believed her unequivocally are now questioning every detail. As for Baldoni, the public scrutiny that once had him painted as a potential wrongdoer is shifting, especially as his team methodically dismantles each piece of evidence that looked so damning at the start. One part of the story some find confusing is the push to decide whether this should be a California or New York lawsuit. But it's vital because the nuances in defamation law vary significantly from state to state. Baldoni, a California resident tied to the Hollywood sphere, argues California has more robust protections in defamation cases and bigger potential damages for reputational harm in the entertainment industry. Fredman's stance is clear. The brunt of the alleged harm to Baldoni's career and Wayfair Studios happened in California, and that's where the case belongs. On the flip side, the New York Times claims ties to New York, obviously. It's in that legal tug-of-war that entire lawsuits can pivot, since the outcome often depends heavily on which state's laws apply. If Fredman succeeds in anchoring the case on the West Coast, that spells trouble for the Times and for Lively's broader arguments. California defamation law might expose them to higher financial damages and more intense legal scrutiny. Translation: the stakes just got higher. Once upon a time, Lively's story commanded overwhelming sympathy. Media outlets, fans, and social platforms rallied to her side, but as each new piece of contradictory information emerges, the conversation is changing. People are now asking questions like, if Lively's claims were solid, why is her lawyer bailing? Or, if this was all true, why does the evidence point the other way? It doesn't help that every fresh twist reveals something that undercuts Lively's initial narrative. An email exchange here, a text conversation there, or the suspicious timing of article publications. News commentators and legal analysts alike are weighing in, many saying Lively's lawsuit looks like it's built on shaky ground. To be clear, Lively still has supporters, but the once near universal backing is no longer guaranteed. Public sentiment is becoming more cautious. After all, if you stand behind claims that end up debunked or impossible to prove, you risk looking like a bandwagon jumper. And in this hyper-connected age, the court of public opinion can be even harsher than an actual courtroom. Among the biggest question marks is how the Times plans to defend itself against Fredman's opposition. They could argue they were simply reporting Lively's lawsuit as it stood. But Fredman's main allegation is that they validated her claims, suggesting they'd investigated them thoroughly, when, according to Baldoni's side, that never happened. If Fredman can show the Times published with reckless disregard for the truth, meaning they either knew or should have known the allegations were flimsy, this could become a landmark case. Media outlets rarely get dragged this far into defamation suits because free press protections in the U.S. are strong. Still, those protections weaken drastically if a court deems the reporting misleading or intentionally biased. At this point, the Times is scrambling to keep itself from becoming a central defendant in a sensational Hollywood meltdown. If the paper is forced to go to trial in California, under that state's defamation laws, the resulting headlines might be more dramatic than any they've written themselves. So, here we are at another crossroads in the Baldoni versus Lively showdown. The difference is, this time, the playing field might have tilted. Lively's allegations aren't resonating the way they once did, and the documents backing Baldoni's defense look stronger every day. Add in a recently departed lawyer, the potential for a court battle with the Times, and the looming question of jurisdiction, and you have a storm that's far from over. The fallout could reshape how celebrities handle legal disputes in the public eye, especially when it comes to enlisting a media powerhouse to bolster their claims. We're left with a pressing question. If Lively's case collapses further, will she face consequences for portraying damaging allegations as fact? And what about the Times? Can they weather the backlash and potential legal blow to their credibility? For now, all eyes are on the next court date, the next leaked file, or the next surprise witness. But one lesson is already clear. When new evidence and a tenacious lawyer converge, even the strongest public narratives can fall apart. Stay tuned, because something tells me the next twist in this Hollywood drama might be the biggest one yet.